All right, court's on the record, Commerce City Municipal Court for the afternoon session of March 17th of 2021. For the people that are on Zoom, please leave your devices muted until I call your case. I will tell you when to unmute. For the people that are in the courtroom, I'm going to call you up to one of the 3 stations there. While you're at the station, please make sure to speak loudly and clearly. One of my responsibilities today is to make sure that everything that you say gets properly recorded. Is this person on Zoom? No, okay. Arnold Alvarado, if you would come to station number 1, please. Good afternoon, Mr. Alvarado. Okay, back on November 12th of 2020, you pled guilty to a traffic violation. I imposed a fine of $240, suspended 160 on the condition you complete the Alive at 25 class. When I didn't receive it by January 13th, I issued the OJW against you. I show that you took the class on December 19th. Why didn't you get this to us by the deadline? All right. Well, I'm going to accept receipt of it. I'm going to resuspend the $160 fine that I reimposed, but I am going to require you to pay the $30 clearance fee since you didn't get it to us on time. Okay? All right. Go ahead and go to the windows, see my clerks. They'll take care of the wiping out the fine and getting this taken care of. All right. If Delano Washington would unmute his device, please.
Yes, I'm here.
Right,
this is Delano.
Give me just a
Good
moment,
afternoon.
Mr. Washington. I just need to pull up your file.
Yes, sir.
There it is. All right, the city attorney is elected to dismiss this case against you. There are no remaining issues to be addressed. I'm going to go ahead and enter the order of dismissal. Either today, tomorrow, or certainly by Friday, my clerks are going to get a copy of the order of dismissal to you showing that this case has been resolved. Do you have any questions?
No, Your Honor.
All right, then you can go ahead and leave the meeting, and if you don't hear from my staff by Friday, give us a call next Monday, and they'll follow up with you. Okay?
Thank you, Your Honor.
All right, thank you.
Bye-bye.
All right, counsel for Michael Jones.
Yes, Your Honor. Good afternoon.
Good afternoon, Mr. Tashjian. Give me just a second. Is your client joining us today?
He is not.
All right, let me go through the questions then. First, if your registration number.
37119.
It's that D that always catches me, Mr. Tashjian.
It gets everybody.
In your last name. All right. I have a proposed disposition that indicates that if, on behalf of Mr. Michael Jones, you plead guilty to the added reduced charge of speeding 50 in a 45 zone, a 1-point violation, the city attorney will dismiss the original speeding charge against him. Is that your understanding of the proposed disposition?
That is a correct description of the disposition.
Okay. And are you representing to the court that you have your client's authority to enter this plea on his behalf?
I do.
Waiving his appearance pursuant to 16-7202?
Yes.
All right, then, in regards to the charge, the added reduced charge of speeding 50 in a 45 zone on January 28th of 2021 at 103rd and Tower Road here in Commerce City, to speeding 50 in a 45 zone. On behalf of Mr. Jones, how do you plead, guilty or not guilty?
Guilty.
I'll accept the plea. Anything by way of mitigation?
He represented to me that he hasn't had a ticket in a number of years. So it sounds like his driving history is pretty good. I don't have the ability to check those driving histories on my own.
Yeah, it's been 2 years since his last ticket. Nothing in aggravation on this one. Let's see. Yeah, his scheduled fine was $80. I'm going to reduce it to $40 plus surcharges and court costs. My clerks are going to get in contact with you by email. We had a busy docket today, and we've got some strange things going on later today and tomorrow, so they may wait until Friday before they administer these cases, but certainly they'll do it by Friday. Again, the fine's $40. There's surcharges. There's court costs. They'll work out a stay of execution for you. Is there anything
thank
else
you, Your
I
Honor.
need to address on this one?
Not on this one, Your Honor. I have one other that we are setting over.
Okay. And what's that defendant's name?
Joanna Velasquez.
Okay, yeah, that one's next. All right, on the record in case number 302-231, this is not an electronic ticket. It's currently scheduled for a pretrial conference on today's date, and you simply want a continued pretrial conference, is that correct?
Yes, please, Your Honor. I've discussed the disposition with Mr. Golan, but it's a little outside the boundaries of what I had previously discussed with my client, so I want to talk to her.
All right, that makes sense. All right, we're looking at a date in approximately a month. So today is March 17th. Take a look and see what your schedule looks like on March, this is a traffic app. Take a look at March 14th at 1:15, April 14th at 1:15.
Wide open.
Good. We'll reset this matter for a pretrial conference on Wednesday, April 14th at 1:15 in the afternoon. My clerks will send you a reminder notice. Again, looking at the original charge, you can appear, and I'll waive the appearance of your client if you want on that date. Otherwise, she can also appear by Zoom. So we'll see you back on April 14th at 1:15. Is there anything else I need to address on this case?
No, Your Honor. Thank you and be well.
And these are the only two cases you have?
Yes, sir.
All right, then you are free to leave the meeting. Thank you very much.
Goodbye.
Goodbye. Okay, Derek Arguello, if you would come to station number 2, please, right there. Good afternoon. All right, I have a document that indicates that if you plead guilty to the added reduced charge of improper lane use, a 3-point violation on January 22nd of 2021 at about 7 o'clock at night in the area of 77th and Highway 2, the city attorney will dismiss the original speeding charge against you. Is this how you wish to resolve your case today? Did you watch the advisement of rights video? Okay, do you understand that if I accept your guilty plea to this reduced charge, you're waiving your right to be represented by an attorney in this case? You're also waiving your right to be presumed innocent of the original charge unless and until the city attorney is able to establish your guilt beyond a reasonable doubt at trial, because by pleading guilty to this reduced charge, you're waiving your right to have a trial. Do you understand that? You're giving up your rights to confront and cross-examine any witness that the city attorney will call in support of the original charge against you. You're giving up your right to present evidence on your own behalf, including calling witnesses on your own behalf, and if your witnesses would not appear in court voluntarily, to have the court issue subpoenas for you free of charge, which could then be used by you to have your witnesses ordered to appear on the date of your trial. You're giving up your rights during the course of your trial to testify or to remain silent, and if it was your choice to remain silent, the fact that you did so could not and would not be used against you to establish your guilt. If at the end of the trial you were found guilty of the original charge, you would have the right to appeal that conviction to a higher court. Do you understand that if I accept your guilty plea to this reduced charge, you're giving up all of those trial and appeal-related rights? Has anyone forced you or coerced you to get you to plead guilty to this reduced charge against your will? Has anyone made any promise to you to get you to enter this guilty plea? Are you currently under the influence of any drugs, alcohol, or medications that affect your ability to understand what you're doing in court today? Then to the added reduced charge of improper lane use, a 3-point violation on January 22nd of 2021 here in Commerce City. How do you plead, guilty or not guilty? I'll accept your guilty plea. Is there anything you want me to take into consideration before I impose the sentence against you? How long have you been driving in Colorado? This looks like it's your first ticket, is that correct? All right, your schedule fine's $120. Because of your good driving record, I'm going to reduce your fine to $60 plus surcharges and court costs. If you go to the windows in the lobby and see my clerks, they're going to tell you what the total is. If you need them to, they'll work out a payment plan for you. Do you have any questions? Okay, go ahead and go to the windows, see my clerk. Okay, Danila Sanchez, if you would unmute your device, please.
Hello.
Hi. Okay, I'm looking at my notes from December, and you were supposed to submit a report showing your re-enrollment in your program and your progress. I don't seem to have one.
I don't recall having to send a report.
Well, how was I
that's-
going to have, this is what I wrote. I ordered you to submit a report directly from the treatment provider to show that you had re-enrolled because you had missed those classes because of the death of your brother, and so that I could see that you were back in and how you were doing.
I have a session receipt. I'm sorry, I must have spaced that. It's been kind of a traumatic few months, which is not an excuse. I have a session receipt that I can email to you guys that shows that I have completed the new I'm in the new Seek and Safety class, which there was kind of like a buffer on that for me to get in. I've completed 4 of those, and I only have, I believe, 10 classes left in total for my whole program.
When will you finish the 10 classes in total for the 10 sessions?
So I did miss the last 2 classes because I was in a motorcycle accident, which I do have verification of, my hospital stuff. I've been in contact with my counselor. She's aware, Idea's aware. Myra wasn't in today, but all I have is my session receipt. So it would be 10 weeks from now and all of it will be done.
Assuming you don't have any other personal tragedies that get in the way.
I know, and I apologize, but some things I just can't control. I've been, I guess, just a walk of bad luck lately. And
Well, I don't
background.
want to send you to jail over this. I want to give you the chance to get through my court order. So this is, March 17th. I mean, this all started in 2019, and, we've been dealing with this in terms of getting you back in and getting stuff done since December. So what I'm going to do basically is set this matter over for another review in 10 weeks. And I need you to talk to the person that you're doing your sessions with. We're contacting you by email. Give them our email advice and your case number and have them email me so that I get a report from them saying that, yes, you're attending regularly and you will be done by X date. I'm going to set this out far enough so hopefully you'll be done by the time we get that next email, but I'm going to make it close.
Never unenrolled, so I don't know. So
Well,
basically,
you missed classes because of your brother's death is what you told me.
yes, I did.
And now you've missed sessions because of your accident.
Yes.
So we need to get you to get this done, okay?
I know. So I completed, I believe it was 23 in therapy plus the 12 education, plus I've completed 4, and it's a total of 42 classes on track B. So doing my math correctly, I believe there's only 10 more.
Okay, well, again, you telling me is one thing, the treatment provider telling me is so much more, okay?
Okay.
So we're going to set this, Alma, can you check to see what we look like on May 27th at 1:15? I know we're off the week after, but May 27th should work, right? I just want to make sure it's not blacked out for anything. Okay, so I'm going to set this for a final review, May 27th at 1:15. I'm ordering you to have your treatment provider send us something, right around then, something that tells me how close you are to being done. If you have another problem, don't wait until May 27th to tell me other problems have arisen and you've fallen behind again. When it happens is when you need to notify me, okay?
So if that happens, I just email the court or do I email you direct?
Email the court. They'll get it to me, okay?
Okay. Thank you.
So we're going to set this over to May 27th at 1:15 for a final review session. Keep in mind, you have a 60-day jail sentence hanging over your head.
I know. I know.
I don't want you to have an active warrant as a result of this case. All right. So you can go ahead and leave the meeting. My clerks will reach out to you by email either today or tomorrow or as late as Friday because we're doing some pretty busy stuff here today. So make sure that if you don't hear from them by Friday, reach back out to my clerks and they'll send you the reminder notice of the new court date and time. Okay?
Thank you so much.
All right. You can go ahead and leave the meeting. Okay. All right. All right, court will be on the record in case numbers 304-220 and 303-028. 4220 is Rhonda Tarango, and 303-028 is Victor Tarango. Good afternoon. Okay. Okay. Right. Correct. All right. Yeah, they always have the right to ask for a continuance, but the dog remains impounded until the next hearing. Well, today is not your arraignment date. Today I have one issue in front of me. First, the only issue that's really in front of me is whether or not the animals will stay impounded until we go through the steps. That's why you're given this hearing so quickly, okay? At your next hearing, again, that's when you'll be arraigned. That's when the charges will be fully explained to you, your rights will be fully explained to you, and then at that hearing, we'll see how you plan on going forward on the charges. Also, at that time, I can take up the issue of whether or not the animals remain impounded. Each time we have a hearing, I can take up the issue of whether or not the animals can be released or if they continue in impoundment. Also, to be candid with you, the city, if they choose to, can seek the destruction of the animals at a future hearing. They can't ask for that today. Today, it's only, are the animals going to stay impounded at the animal shelter until the next hearing? And to be candid, if you ask for a postponement, they'll stay impounded until the next hearing. And at the hearing on impoundment, the people, meaning the prosecutor, only has to prove that the animals fit the definition of dangerous animals for the purposes of this hearing, and they only have to prove it by preponderance of the evidence, not proof beyond a reasonable doubt. Preponderance of the evidence is more likely than not. To meet that burden in that code, the new code, it sets out what the criteria is for me to determine whether or not they meet the definition and to order continued impoundment. But you absolutely both have the right to be able to consult with an attorney before making a decision on whether or not to contest this issue, impoundment, and whether or not you want to have them represent you on the underlying cases. So that decision is entirely yours. Okay. Does your mother need an interpreter? Does your mother need an interpreter? Okay, it's just I heard you whispering to her, and I wasn't sure what you were. Okay, that's fine. All right. Okay, then let's have a seat. It looks like the microphone's on. Mr. Golan, are you prepared to proceed? if you want to figure, Mr. and Ms. Tarango, Mr. Tarango and Rhonda Tarango, section 4-4001, it's on page 16 of 21. I don't know which one you have. Yeah, page 16 of 21. Okay, that's fine. You can present it any way you want. Mr. Victor Tarango, if you will look on page 17, I think it's 17, wait. No, I'm sorry, page 18 of 21, the paragraph marked 3. It says, at the hearing, the burden shall be on the city, meaning Mr. Gollin, to establish by a preponderance of the evidence, that means 51% of the evidence, except as specifically noted that continued impoundment is proper because the animal, 1, is likely to be found at a future disposition to be a vicious animal, 2, is likely to be found at a future disposition to be a dangerous animal, and the owner fails to establish the animal cannot be safely maintained, cared for, and controlled without damage to the animal or the community. 3, is likely to be found at trial to have been as owned or kept in violation of this chapter or any other law. And 4, the animal is likely to be experiencing, that's for neglect of an animal, so that one doesn't apply. So basically what is in front of me today is that today the animal poses a danger to the community and is likely, meaning more likely than not, to be found at a future hearing to be a vicious animal or a dangerous animal that you're unable to maintain in a manner that provides safety to the community and public as a whole, okay? So it's one or the other, okay? Do you have any questions about what the standard is? I'm sorry? Okay, Rhonda Tarango, do you have any questions about what I have to find? Okay, let me just ask. I know that there is more than one dog. Rhonda Tarango, which dog is yours? Okay, and that's like a Malamute, a Husky? Okay. And the other dogs are yours? Okay, that's fine. All right. Now, the other thing you need to keep in mind is when the city council wrote this, and it's brand new, when they had the city attorney write this, they wrote it in such a fashion that basically everything is done informally. They're going to tell me their side. If you want to, without going into the facts of the case, because I don't want to do that because you're represented by an attorney, but to go into the facts of how you're maintaining the dogs, you can do that informally too, and then I just have to make the decision on whether or not to continue the impoundment. Okay? All right, go ahead, Mr. Gollin. Well, even though it's informal, I'm still going to put you under oath. Do you swear affirm under penalty of law that the testimony and evidence you'll provide to the court today shall be the truth, the whole truth, and nothing but the truth? Thank you. Please be seated. No. Yeah, there. Whose report is that in? Why are we asking Officer Nicholas about it then? I know, but he obviously doesn't remember what he read, so let's move on to stuff that he has personal knowledge of. I'm sorry, I didn't hear that. Okay. All right. Um, Rhonda Tarango and Victor Tarango, this is not a trial, so I'm not going to open the officer up for cross-examination. It's basically, I need information, and so we'll let Officer Nicholas stand down. Mr. Gallen, do you have any additional witnesses? Okay, go ahead and call Officer Ontiveros. Do swear affirm under penalty of law that the testimony and evidence you provide to the court today shall be the truth, whole truth, and nothing but the truth. Please be seated. Mr. Gallen, the court's satisfied with regard to King and Beast. I don't need to hear any more detail regarding the injuries or their behavior. I am only at this time interested to hear any specific evidence the city may have with regard to Rafiki being either vicious or dangerous. I'm sorry, the what? My understanding is we don't have it currently in evidence, but... Oh, the doorbell ring video? Yeah. Okay, I just didn't hear what you said. So, you want the doorbell ring video? That's correct, sir. And, who does that relate to? Which, is that going to Victor Garcia? Victor Garcia. Okay. Can you just tell the judge what you observed from the video in terms of the three dogs? So from the video, I can see Mr. Garcia parked his vehicle on the north Yeah, do you have any evidence that Rafiki bit any of the victims? Is Officer Zamora available? Yeah, sir, this isn't an opportunity for you to talk. You do? Oh, again, rules of evidence are relaxed. Have you read Officer Zamora's report? I have. Ask her. Maybe she remembers what she read.
So according to Officer Zamora's report, the day of the incident, as I asked I was en route with two dogs, which was Beast and King. Officer Zamora got on the radio and said that there was two dogs, and I asked him to clarify with his victim/witnesses if Rafiki was involved. And his witness, his victim's witness, which is Ruben Villanueva's brother-in-law, Arturo Herrera, stated that the dog, Rafiki, was involved with the attack/fight. I would like to add to that the following day when Officer Hadley and I went back out, we spoke to Arturo Herrera, brother-in-law to Ruben Villanueva, and I tried to speak to Mr. Herrera since he only spoke Spanish, and I asked him if he actually saw Rafiki fight either himself or Ruben Villanueva, and all he could tell me was that the dog called them on top, because he neither confirmed nor denied that an actual fight came from Rafiki.
All right. Thank you. Yeah, again. Yeah, they're all in. I mean, it's informal, so peoples 1 through 9 are all admitted for the limited purposes of today's hearing. I know. All right. Thank you. You may step down. Okay. With regard to King and Beast, I'm going to find that 1 through 9 satisfy me that at a future hearing, it's possible that they could be found to be both vicious and dangerous. So there isn't anything that you're going to be able to tell me that's going to convince me to release King and Beast before the next hearing, okay? So I'm not even going to have you try. Now, Ms. Rhonda Tarango, with regard to Rafiki, there is a chance that additional investigation or additional evidence may show up to tell me that Rafiki could be found at a future hearing to be dangerous or vicious. Let me just ask you this. Tell me what your setup is at home. If I release Rafiki back to you, what steps can you take to make sure Rafiki doesn't get out? And I hate to tell you this, the standards that I have to apply are fairly strict, okay? Okay, basically you're going to have to keep Rafiki in the house or in a structure from which the animal cannot escape by any means. The animal shall be confined in an enclosure, meaning a fenced yard, with a lockable latch, a secure top. If you have a dog run, it's got to have a top to it, and a concrete base. These are the things that are possibly required. Is your yard fenced? And is it completely secure? In other words, there isn't any places like an open driveway gate or anything like that? It's going to have to stay closed and locked. And I'm going to suggest to you, if you use it for a car, only put the car in and take the car out when Rafiki's in the house. That would be an absolute minimum standard. Do you understand that? If you can, leave the gate locked and park in the street. Yes, ma'am. Mm-hmm. Is the front porch screened in? No. Okay. Mm-hmm. Mm-hmm. Mm-hmm.
So he has had mouth problems ever since. This dog cannot bite.
Okay, let me ask you this. On your front porch, is it possible for you to put him on like a 10-foot lead and have the lead attached to something so that he can't get more than 10 feet away from the front porch? Okay. Okay, well, I'm going to, I'll be candid. I don't have any evidence that he's going to be found to be more than a dangerous animal. Vicious animal is the highest standard. Dangerous animal is the next one. So your yard has to be fully enclosed by a fence. It has to remain locked in the sense that way little kids don't come and open the gate and let the dog out. You're going to need to have Rafiki attached, if he's out on the front porch, to a lead. It can be as long as 10 feet. If it's less, that's fine. But if it's longer than 10 feet, it's not going to work. And it's got to be secured. It can't just be like tied in a knot on a post. It has to be secured to something. And then the rest of the time, he's got to be in the house, okay? If you have him out like in the yard and stuff, an adult, 18 years of age or older, has to be out there until you take him back in or reattach him to the lead, okay? Do you have any questions about what I'm ordering? Is there anything else you want me to know that you can reassure me that Rafiki, if I let him get released to you, is not going to pose a danger to the community? Do you have the records about having the teeth extracted? Do you have the records about having the canine teeth extracted? So the answer to my question would be yes, and it's already been provided? To who, do you know? Do you guys have it? Yes. Okay, and do the medical records verify that Rafiki's had? Okay. Yeah, unfortunately, this rule trumps emotional support dogs. At least until federal court tells me otherwise. Perfect, okay. Yeah, oh no, I can tell he's not a young dog by the photograph. All right, so I am going to, based on the evidence that I've heard thus far, based on the standard of law as contained in section 4-4000 et sec, meaning all of the 4000 series, I'm going to find that at a future hearing, it is possible that king and beast could be found to be vicious animals. I'm going to order king and beast to be maintained in impoundment until the next hearing, at a minimum. With regard to Rafiki, I'm going to order Rafiki returned to Ronda Tarango with the conditions that I just outlined. They must be maintained in a locked, secure facility within a fenced yard, only outside onto the front porch with a lead attached to a secure device no more than 10 feet long. If he's off the lead outside within the yard, he must be in the presence of an adult 18 years of age or older until Rafiki is returned either inside the house or reattached to the lead. He's not allowed to leave the premises except to go to routine veterinary checkups or anything like medical animal emergencies. You can take him out for that. But no taking him to the public parks, no taking him for walks, nothing like that between now and the next hearing. Mr. Goen. When did he get taken in? Okay, yeah, that's true. I forgot. 10-day quarantine. Yeah, they're right. That's state law. It's a mandatory 10-day quarantine. All right, so once the quarantine expires, you can take Rafiki out of impound. And do we have an arraignment date set yet on this case? Okay. Sure, we'll do both of those on the same date. Yes, 304-220 and 303-028. Yeah, I know. So Are you been in communication with Mr. Decker to know what his availability is? Yeah. Yeah, I'm probably going to be setting this for April 7th, 1 o'clock in the afternoon for arraignment. If that doesn't work for Mr. Decker, he knows how to enter his appearance and contact the court and get it rescheduled. All right, so let's set both of these matters for arraignment on Wednesday, April 7th at 1 o'clock in the afternoon. Yes. Yeah, I'm setting it at 1 o'clock in the afternoon, so that means they'll be here. And that means if we have to have all of the victims and witnesses here, you can anticipate that we'll try to do the rest of the arraignment docket and then do the disposition hearing after that. And hopefully Mr. Decker's available. All right, so for the two of you, if you'll go to the windows in the lobby and see my clerks, they're going to give you a reminder notice of the new court date and time. Officer Ontiveros and you should be in contact, because once the quarantine is over, you can pick up Rafiki, okay? Do you have any questions about my order? Okay, do you have any questions about my order? All right, go to the windows, see my clerks. so I need those cleaned. Who do I have on the phone?
Me, Jose.
Let me have what's your full name?
Jose Dosdala.
Okay, good. So, I'll take care of this one. Okay, Mr. Dosado, I'm getting a lot of background noise from you. Or it could be Jessica Ruby. Miss Ruby, could you mute your device? Okay,
You also have a
clear.
Dominic Duran. Oh, sorry.
Okay.
Hello?
Yeah, if Jessica Ruby could mute her device. I'm on the record regarding Jose Dosado. Okay, good afternoon, Mr. Dosado.
Good afternoon. How are you?
I'm good. Hey, your matter is scheduled for a pretrial conference for today's date. The city attorney is still needing you to get a letter from your insurance carrier, so he says that you need more time. Is that correct?
Yeah, that's correct.
All right, we'll reset your case for another pretrial conference. You need to make sure you get everything you need by that next court date. Do you understand?
Oh, yeah, I understand. My apologies for.
That's okay.
It's been hard to get a hold of the insurance, but yeah, I just actually got in contact with them today, so hopefully I should have it by next court date or pretty soon.
So when you leave the meeting, my clerks are going to be in contact with you by. Give me a second. My record turned off.
Okay.
Come on. I don't know when, but FTR turned off. Okay, it turned off at 1:50. I don't know why either. It just did it. Give me just a second. I'm still waiting for our device to turn back on. Okay, there it goes. All right. My clerks are going to get in contact with you by email. They'll give you the notice of the new court date and time. They may not get that notice to you today. It may not be until Friday. But sometime this week, you'll get that notice of the new court date and time, okay?
Okay, that's fine. Thank you.
All right. You can go ahead and leave the meeting.
All right. Thank you, sir. You have a good day.
You too. Dominic Duran?
Yes.
Oh, okay. I didn't realize you were on Zoom. Okay, yours is the number ending in 474, is that correct?
Yeah, 8474.
Okay. Hold on for just a second. Oh, no, it's a hard copy. Never mind. I have a document that indicates that if you plead guilty to the added reduced charge of speeding 75 in a 45-mile-per-hour zone, that's a 6-point violation, and attend a level 1 driving class, the city attorney will dismiss the original speeding charge against you. Is this how you wish to resolve your case today?
Yes, that is fine.
Okay, did you watch the advisement of rights video?
Yes.
All right, I'm going to go over some of those rights with you. Do you understand that if I accept your guilty plea to this reduced charge, you're waiving your right to be represented by an attorney in this case?
Yes.
You're also waiving your right to be presumed innocent of this original speeding charge unless and until the city attorney is able to establish your guilt beyond a reasonable doubt at trial, because by pleading guilty to this reduced charge, you're waiving your right to have a trial. Do you understand that?
I do, Your Honor.
You're giving up your rights to confront and cross-examine any witnesses that the city attorney would call in support of the original charge against you. You're giving up your right to present evidence on your own behalf, including calling witnesses on your own behalf, and if your witnesses would not appear in court voluntarily, to have the court issue subpoenas for you free of charge, which could then be used by you to have your witnesses ordered to appear on the date of your trial. You're giving up your rights during the course of the trial to testify or to remain silent, and if it was your choice to remain silent, the fact that you did so could not and would not be used against you to establish your guilt. If at the end of the trial you were found guilty of the original charge, you would have the right to appeal that conviction to a higher court. Do you understand that if I accept your guilty plea, you're giving up all of those trial and appeal-related rights?
Yes.
Has anyone forced you or coerced you to get you to plead guilty to this charge against your will?
No, sir.
Has anyone made any promise to you to get you to enter this guilty plea?
No.
Are you currently under the influence of any drugs, alcohol, or medications that affect your ability to understand what you're doing in court today?
I am not.
then to the added reduced charge of speeding 75 in a 45-mile-per-hour zone, a 6-point violation on January 24th of 2021 at 8:45 in the evening in the area of 99th and Highway 2 here in Commerce City. How do you plead, guilty or not guilty?
I plead guilty.
I will accept your guilty plea. Is there anything you want me to take into consideration before I impose the sentence against you?
No, Your Honor, just that I will slow down.
This is more than just slow down.
Yeah.
There's nowhere you can legally drive that fast. I mean, there just
No,
isn't.
I know.
Your driving record
I'm
also
sorry.
shows that you got a ticket in Thornton in May of 2020. Is that entry correct?
Yes, sounds right.
All right, give me just a moment while I do the math. All right, your scheduled fine's $420. I'm going to impose the $420. I'm going to suspend half of it, $210, because I'm going to order that you do the level 1 driving class. All right, so
Okay.
when you leave the meeting, my clerks are going to get in contact with you either today, tomorrow, certainly by Friday. They'll tell you what the total
Okay.
is of the non-suspended portion of the fines and costs, and if you need them
Okay.
to, they'll work out a payment plan for you. They're also going to
Okay.
give you the referral to the people that put on the level 1 class. They'll give you a deadline of about 6 weeks within which to complete the class. Once you get this information, you need to contact those people right away, get the class
Okay.
done, make sure that the original certificate of the completion gets filed with my court by the deadline. That's your responsibility.
Okay.
Make 2 copies of it, because once your insurance company gets wind of these 2 tickets, they're probably going to raise your insurance rates, and they might give you a discount for having done the driving class. The other
Okay.
copy you hold on to just in case you end up in front of DMV trying to preserve your driver's license. It's always good to have a
Okay.
copy of proof of completion of the class for DMV. So the original is for the court, a copy for your insurance carrier, and a copy for DMV just in case. That's what you need to do with
Okay.
the certificate of completion, okay?
Okay.
Do you have any
I will do
questions?
that. No. So all this you just said will be gotten to me
Email.
by in email? Okay.
Yeah, either today, tomorrow, certainly by Friday, okay?
Okay. Okay. I'll be looking for it.
Okay, then you are free to leave the meeting.
Okay. Thank you. Have a good day. Bye.
You too. Is she on Zoom? Is she on Zoom? Okay. No, she's fine. Jessica Ruby, can you hear me? Oh, she's not this one? This phone call? Okay.
My name's Melanie Wilbur.
Okay, I need you to mute your device. I'm going to be calling a different case first, okay?
Okay.
Is he going to get her out of the breakout room? Miss Ruby, can you hear me?
Yes.
Okay. I have a document that alleges that on May 25th of 2020, at about 8 o'clock at night, from there at 5990 Dahlia Street, that's the Walmart store located here in Commerce City, it's alleged that you committed the offense of theft. Do you understand what it is you're accused of doing?
Yes, sir.
All right, the city attorney said that he read the elements of this charge to you. In other words, he explained what he would have to prove in order for you to be found guilty of committing this offense. Did he go over those elements with you?
He did.
All right. He also says that you and he have worked out an agreement and we're going to schedule this case for a new court date. Between now and that next court date, if you complete 16 hours of community service, a petty theft class, agree to stay out of the Walmart, and commit no new law violations, when you come back to court, if everything is in order, I can dismiss this case. Is this how
Correct.
you wish to resolve your case?
Yes.
Okay. Let me ask, are you currently a member of or a veteran of the United States Armed Forces?
No, sir.
Okay, give me just a moment while I fill out some paperwork. Okay, in addition, you're going to owe a $50 warrant fee for your failure to appear. Back in August of 2020, you failed to appear, and then you contacted us, and I vacated that warrant and the hearing from August. We reset this to September 24th. When you failed to appear on that date, I issued a new warrant, and that's the $50 warrant fee that you'll have to take care of. Right now, if you comply with everything else, it's not going to cost you anything to the court beyond the $50 warrant clearance fee, and that'll be due on your next court date, okay?
Okay.
All right, so when you leave the meeting, my clerks are going to be in contact with you by email. They're going to give you the notice of the new court date and time. It's going to be in about 6 weeks. They're going to give you a referral to the people that put on the petty theft class. It's important that you contact those people right away, get the petty theft class done. When you're done, they're going to give you what's called a certificate of completion. It's your responsibility to make sure that certificate of completion gets filed with my court by the next court date. My clerks are also going to give you the form we used for community service. You can do the community service anywhere. It does not need to be done in Commerce City. But I do require that the place that you pick to do the community service must be a legitimate nonprofit agency. I won't accept it if you simply do free work for friends, neighbors, relatives, or for a for-profit business. So make sure it's a legitimate nonprofit, do the work, have them fill out the form, and then again, it's your responsibility to get that form to us for the next court date. Then it's simple. Stay out of the Walmart, stay out of trouble, and then send in, you can use SitePay, which is an online payment method, to pay the $50 so that when I see you the next time or hear from you the next time, all I'll be doing is dismissing the case. Do you have any questions?
No, sir.
Okay, I'm vacating the warrant on today's date, so you don't have to worry about that anymore. My
Thank you.
clerks will email you with the notice of the new date, the referral to the class, the community service form. They may not get to you today, maybe tomorrow, it probably will be on Friday, but they'll get this information to you, okay?
Okay, thank you.
All right, then you can leave the meeting.
Thank you.
Mm-hmm. Here, okay. There's a bunch of blank Rule 11s. Mm-hmm. Do you know what station we're on? Oh, this person's on Zoom? Okay, Melanie Wilbur, if you will unmute your device, please.
I'm here, Your Honor.
Okay. All right, this matter's already been set for 2 pretrial conferences. You first appeared on February 20th of 2020. You failed to appear on September 3rd of 2020. All right, since you appeared today, I'm going to go ahead and cancel the warrant that's out there for your arrest. There's going to be a $50 fee that you're going to have to pay when everything is said and done on this case.
Okay.
Okay, so first let me take care of vacating the warrant. All right, let's see what, All right, so at this point, I'm not going to set this case over for another pretrial conference. It looks, because you've already had three, actually. The city attorney says that you claimed you've already done the class. Is that correct?
No, I paid for the class, but I missed the time when I was supposed to be there in the morning. I was moving storages that weekend, and I didn't mean to space it, and I did, but I paid for the class. Like, I had the packet and everything that they sent me for after I paid for it, but I didn't make it to the class before it was over. And I tried to get a hold of them. I sent them an email and I tried calling, and I haven't had anybody respond back to me.
Well, you
And when
need
I
to
called
get the
before-
class done. Otherwise, on the date that I'm going to schedule, we're either going to dismiss it because you've done the class, or we're going to go forward with the trial, or you can plead guilty at that time. But the case will only be dismissed if you get the class done before the next court date. You understand that?
Yes, sir.
All right. So for now, I'm going to enter your not guilty plea. We'll schedule this case for a trial to the court, unless you want to schedule it for a jury trial. You are eligible for a jury trial.
No, the regular trial is fine.
Okay.
And also, Your Honor, I was going to see can I get a voucher for the class?
No, ma'am. I can only issue vouchers when I sentence people to the class. This is a part of a plea bargain between you and the city attorney in an effort to get the case dismissed. I don't pay for people to get their case dismissed. Do you understand the difference? In other words, if
Yes,
you
sir.
get found guilty as part of a sentence, I can sentence you for the class and I can have the court pay for it. But when it's part of a plea bargain between you and the city prosecutor, the court can't pay for it. Okay?
Okay.
All right. So you'll need to contact those people, get the class done. According to Mr. Gollan, he'll agree to accept it up to 2 weeks before the trial date. So we're going to set your case out about 8 weeks to give you plenty of time to get it done. Okay?
Okay.
All right. So when you leave the meeting, my clerks are going to give you another referral to the people that put on the Making Better Choices class. They're also going to give you the new notice of a trial date. And again, make sure you get the class done and the proof submitted to my clerk in advance of the trial, and then all you'll owe is the $50 warrant fee, okay?
Okay.
Do you have any questions?
No, sir.
Okay, you can go ahead and leave the meeting.
Okay.
I have to log out of full court by 5 o'clock today, according to this email. I know. That's cutting it close for me. Looking at the docket, I have quite a few FTAs, right? Okay. Yeah, I don't have any files. I have one person on Zoom. Is this the person you're talking about? I can't read his last name. Okay. Yeah, because he's not on the docket. How about the people that are in the courtroom?
Good afternoon, Your Honor.
Good afternoon. I think we're waiting to put you in a breakout room.
Yeah, I did find out that I have a ticket.
Yeah, hold on for just a second. What's that?
Okay.
He can make it orally, make a motion. Yeah. All right. I'm going to go ahead and call your case now. On the record regarding Jamsed Solikonon, this is from April 8th of 2015. The default entered on June 3rd of 2015. What would you like to ask me about this case, sir?
So, Your Honor, yeah, at that time I didn't intentionally, it wasn't on purpose. I didn't miss the court on purposely, And then I found out that I was fined, and by default judgment, I think I got fined. And
Yes,
I have sent by mail the check, and I thought that it was taken care of at that time. And so, but a few days ago, I just noticed that I have the fine on my record. So that's why I did contact the court clerk and ask it for the hearing. And I'm trying to find out. I mean, it looks like you didn't receive the payment, and that's why it's on my record. So that was my first ticket in my entire life. That's why I'm a little surprised. I thought that it's gone, So, Your Honor, I'm trying to find out the way how to settle it, or I don't know. I mean, whatever.
I don't even have jurisdiction to reopen the case for any purpose. The only thing that can be done at this point is you'll need to pay everything in full, and then there's a $30 clearance fee that the Department of Motor Vehicles charges to show that this case is satisfied. I show that you have a New York driver's license. Is that correct?
Yeah, I used to live in New York and then move it to California, and now I'm in Chicago, Illinois. That's why it is a little, confusing that maybe I didn't get it on time. I don't know, but I have sent it on at that time in 2015.
Yeah, but we obviously didn't get it unless you
Yeah.
have a canceled check. It's still outstanding. So what needs to be done is it needs to be paid in full, and
Sure.
then the clearance will be sent to the Department of Motor Vehicles in Colorado and then circulated nationwide through the Interstate Compact. So when you leave the meeting, my clerks are going to tell you how much you owe. Once it's paid, everything gets cleared up.
Okay. So, Your Honor, there is no way to make the settlement, right? I mean,
No, that opportunity ran out in August of 2015.
so there's no way to reduce the amount, right?
Nothing. I can't even reopen the case. The default stays in effect until the payment is paid, and then the lien against your driving privilege gets removed. But the default will still show. It'll just show as satisfied.
It will show satisfied, so we cannot dismiss the case, right? There's no way.
No, I can't even open the case to dismiss it. The only thing that can be done at this point is, right now, there's a lien on your driving record in Colorado and throughout the United States showing that you defaulted on this case and your privilege to drive has a block on it. You should not have been able to renew your driver's license since June of 2015 in any state.
Well, that's the interesting thing. I didn't have any issue. I just recently realized that I have this record, and this is very surprising for me, actually.
It surprises me that you were able to get a driver's license in Illinois with this thing still outstanding in Colorado against you.
Yeah, yeah. Well, I will pay it off as soon as possible.
Sure.
So it's gonna be removed, right?
What's
From my
that?
record. It's gonna be removed from my record once I pay it, right?
Well, it'll show as the default is satisfied. It doesn't ever get removed from your record. Right now, it's a lien against your driving privilege. It'll show that the lien has been cleared, and so the matter is settled, but it'll still show on your record.
Mhm.
It's a speeding ticket from 2015. The speeding ticket on your driving record will always show up there.
Always, right?
Yep.
Okay.
Okay. So
Thank you
when you
so
leave
much.
the meeting, my clerks will be in contact with you. They'll tell you how much you owe. They'll give you information on how to pay it electronically rather than sending in a check. It'll probably be quicker that way. Okay?
Yeah, yeah. Yes. Thank you, Your
All right.
Honor.
All right. Good luck. You can leave the meeting.
Okay. Have a good.
So are we done on Zoom then? No? Okay. Okay, I'm going to reduce it then. Is he on a phone or on a computer? And he still hasn't spoken to Adam. Oh, where the light comes through? Okay. Sure, give me just 1 second. Okay, I tried to add a face sheet. Oh, no. And it said, error, document cannot be processed. There are no hearings attached to this case. This one, not this one. I'm going to go ahead and do index to case and see what happens. No, it's not going to let me. Okay, so now, how do I go back? Just go back to work queue. Okay, so I went to this. I clicked this one. I went to docket management. I looked at it. It's a parking ticket. Okay. I went back. I went to Adams, plea by mail. I went to here. Adams dismissing it, so I was going to do a face sheet showing that it was being dismissed. So I just closed this one. And so then I went to cases, documents, document processing. Oops. And then I went to face sheet for traffic. And then I hit process, and I got that.
He didn't create you a separate one for parking? Because there's no hearings associated with parking tickets.
Right, but I don't have a face sheet parking.
Okay, that's what I'm saying, he didn't create one.
So I should get a face sheet for parking? The other thing I could do is try to, okay, I can do this. I can, for this particular one, I'm going to go ahead and try to edit Adams' Rule 211 by signing and dating it. Okay? I can try and do that. Mr. Lobdell, give me just 1 minute and I'll be with you. I just started this thing and I'm trying to fix it. Yeah, I think it's going to let me do that. If I can do it this easily on the Rule 211, I'll be fine. It went through. Just I edited the Rule 211, and but I'm dating it and signing it on his motion to dismiss. So that'll work. It gets us to the same place. All right. On the record in case number 303979 regarding Mike Lobdell. All right. This matter is scheduled for a trial of the court on today's date on a single charge of, under the old animal code violation, the charge of harboring a vicious or dangerous animal. The new animal code violation actually just went into effect a week ago, so that's why I'm referring to it as the old versus the new. And is Mr. Gollin correct that you want to consult with an attorney prior to proceeding to trial in this case? Mm-hmm. Okay, that's fine. Mr. Lobdell, you need to understand that you have the right to a speedy trial under Colorado law. In municipal courts, that right runs from the day you pled not guilty, which in this case is February 4th of 2021. That means that we would have to bring your case within 91 days of that date. Now, by asking for this postponement today, that statute of limit, or your right to a speedy trial, runs again, starting from today's date. So your case would have to be tried within 91 days of today's date. That's called your right to a speedy trial, as I just indicated. Do you understand that by asking for this postponement, the 91 days starts to run again from today? Has anyone forced you or coerced you to get you to waive your right to a speedy trial against your will? Has anyone made any promises to you to get you to waive this right? Are you currently under the influence of any drugs, alcohol, or medications that affect your ability to understand what you're doing in court today? Okay, I'm granting your motion for a continuance. You need to understand that I give each side like one continuance. I rarely give anybody two continuances unless there's like an actual emergency. Just so that you're aware, I probably won't postpone this case again, okay? How much time? Yeah, well, it's good to have all the information that could affect the outcome of the case with you. Mr. Gollin? My suggestion is, Mr. Lobdell, if you have an attorney who enters this case, have him reach out to Mr. Gollin. I'm planning on setting this case out about 6 weeks, because I think that's where we're at with trial settings. So if you hire an attorney right away, have him reach out to Mr. Gollin to see if a disposition can be reached. If it can, great. If it can't, then we'll proceed to trial in about 6 weeks, okay? All right. Your motion to continue is granted. We'll reset this matter for a trial to the court. Any witnesses that are present, their subpoenas are continued into the new trial date. Mr. Lobdell, if you'll go to the windows in the lobby, see my clerk, they'll give you the notice of the new trial date. Mr. Gollin, your witnesses can also get a reminder notice of the new date at the windows in the lobby. If you'll go ahead and proceed out there, Mr. Lobdell. Is he ready? No. Then I'm going to keep going on my cue. Is he already in a breakout room then? Yeah. Okay, I was supposed to say, because I'm not showing him, but I believe you. You wouldn't lie to me. And I still don't know that I ever told that guy he didn't have to do the essay. I mean, that just, have you ever heard me say that to anybody? Okay. Like I said to him, I don't even know how that would have come up. And I believe that, you know, Christopher may have said, yeah, it's not required on traffic because we generally don't. But I certainly would have remembered if somebody had asked me in open court and I told them that. Right? I just don't recall ever having done that. Ever. Oh, these are all parking tickets. Ah, it kicked me out. Dang it. Of course, I may have hit the wrong button. Okay. There's that. See, this one did have a face sheet in it, but it's still just a parking ticket being dismissed. So I guess it's hit and miss. Sometimes they do them, sometimes they don't.
Did you say to call? Are you still on there?
On this one where you're dismissing one and we have the other, do you know if he's already pled guilty in the other one?
Parking ticket?
Yeah.
Yeah, I think I did that, when did I do that, Monday?
Yesterday.
Yeah, you know what, I thought to myself, I'm a fucking idiot, because what if they don't plead him otherwise?
Right. So I'm
I
gonna,
don't know, but I'm willing to risk it.
okay. That's good enough for me.
Can you visit me with the pound cake with the file?
Mm-hmm.
I did, actually, that's another reason, in the middle of the night when I couldn't sleep, I'm like, that doesn't make any sense what you just did. Wait, you need Chandler now.
Mr. Dottavio, hold on for just a minute. I've got the the information on your case, but I'm waiting for the court file. So just hold on for just a minute. We'll be right back with you. All right. I've got two cases for you. The first one is case number 304103. On this one, back on January 7th of 2021, you pled guilty to the charge of harassment. At that time, I imposed a $50 fine plus surcharges and court costs, imposed and suspended a 15-day jail sentence on the condition that you do the one-day alcohol education, pay your fines and court costs, have no contact with James or Penny Dottavio. When you fail to comply with submitting proof of completion of the one-day class and pay the fines, I issued a warrant for your arrest. I issued that warrant on February 17th. Let's see. The second case I have for you is case number 304444. It alleges that on December 14th of 2020 at 2 o'clock in the morning in the area of 11400 Oswego Street, you committed the offenses of unlawful possession and consumption of alcohol by an underage person and having an open alcohol container in public. The date of this offense was before the date of sentencing in your other case, so I don't have to impose the 15 days in jail. You were supposed to have appeared on February 4th. When you failed to appear, I issued a warrant for your arrest. I'll cancel both warrants for your arrest since you're appearing here. The city attorney says that you and he have worked out an agreement on the new case that if you complete 16 hours of useful public service, commit no new law violations, he will dismiss this case. Is that how you wish to resolve your new case?
Yes, sir.
Yes, sir.
All right, did you watch the advisement of rights video?
Yeah.
Okay. Give me just a moment while I fill out some forms. All right, so in the new case, we're going to schedule your case for a pretrial conference. My clerks will send you an email that'll include the notice of the new court date and time. You owe the $50 warrant fee on the next court date, which is going to be in about 6 weeks. They'll also send you the community service form. You can do the community service anywhere. It doesn't have to be done in Commerce City. The only requirement that I make is that the place that you pick to do the community service must be a legitimate nonprofit agency. I won't accept it if you simply do free work for friends, neighbors, relatives, or for a for-profit business. So on case number 304444, you're going to owe the court $50 plus proof of completion of 16 hours of useful public service. In case number 304103, I'm going to cancel the warrant. In this case, you also owe the warrant fee, and you also owe me the one-day alcohol education class through NCTI. I'm going to make that due on the same date as your pretrial and your other case. Do you understand that?
Yeah.
Okay, so it's really easy for me. Which would you rather do, a one-day class online or 15 days in the Adams County Jail?
But I'd rather do the class.
Good. I would think so. But, you know, I've been proven wrong a number of times. So let's get it done by the next court date in about 6 weeks, okay?
All right. Yes, sir.
All right. So again, in this case, you're going to owe me $50. Oh, no, you're going to owe a little more than that because there's still outstanding fines and court costs. My clerks will tell you how much you owe, but then they'll also owe the class, and they'll give you another referral to the class. So we'll see you back in about 6 weeks. Hopefully everything's done so we can wrap these two cases up. Do you have any questions?
No, sir.
Okay, you can leave the meeting. My clerks will be in contact with you.
All right. Thank you.
Mm-hmm. So you're setting these both on the same date. One's a pretrial, the other's a sentence review. All right, I'm going to leave the meeting because we're done, right?